It is well known that the legislature make laws, the executive executes the laws made by the legislature, and the judiciary interprets and applies the laws as the circumstances demands. After considering the constitutional development on the position of law with regard to anti-defection under the 10th schedule, let us look into the judicial interpretation of the same by the Indian judiciary. The first challenge to the anti-defection law was made in the Punjab and Haryana High Court in case of Prakash Singh Badal and others versus Union of India and others. One of the grounds on which the law was challenged was that paragraph 2 clause B of the 10th schedule to the constitution violated right of freedom of speech under article 105 of the constitution, wherein the court held, I quote, "So far as the right of a member under article 105 is concerned, it is not an absolute one and has been made subject to the provisions of the Constitution and the rules and standing orders regulating the procedure of Parliament. The framers of the Constitution therefore never intended to confer any absolute right of freedom of speech on a member of the Parliament, and the same can be regulated or curtailed by making any constitutional provision such as the 52nd Amendment. The provisions of para 2 clause B cannot therefore be termed as violative of the provisions of article 105 of the Constitution." Unquote. In the case of Quixota Holohan versus Zahcholho, the constitutional bench headed by Justice Venkatachala gave an elaborate, lucid and dynamic judgment. The Supreme Court in this case gave its operative conclusions indicating reasons to follow, and by its judgment gave the reasons on the questions whether the 10th schedule to the Constitution inserted by the Constitutional 52nd Amendment Act seeking to penalize and disqualify elected representatives is violative of the fundamental principles of parliamentary democracy and is therefore destructive of the basic features of the Constitution. Paragraph 7 of the 10th schedule in terms and in effect brings about a change in operation and effect of the articles 136, 226 and 227 of the Constitution, and therefore the bill introducing the amendment would require ratification of one half of status as envisaged by the proviso to article 368 clause 2. The non-compliance with the proviso to article 368 clause 2 would render the entire bill vitiated and an abortive attempt to bring about a valid amendment, or would paragraph 7 alone be invalidated with the application of the doctrine of severability. The 10th schedule created a new and non-justiciable constitutional area not amenable to curtail adjudicative process, and whether paragraph 6 subclause 1 in imparting a constitutional finality to the decision of the chairman or speakers, and paragraph 6 clause 2 in the event of attracting immunity under articles 122 and 212, which will bar judicial review.